Don, going back, if you wouldn't mind, going back to the original notice submission, clarifying that we were going back and forth, it was mandated or whatever.
Yeah. I'm not sure what question you're asking.
Okay, the question came up originally about whether we said that you had to submit a plan 6 years in advance, and someone was questioning that whether it was preparation to submit a plan 6 years in advance. And because you did it 2 years ago, and this is the same process we're going through now. Only 2 years ago, you didn't have a public benefit determination at that time. You didn't go through that.
We did.
You did. I'm sorry. Okay. That was in effect. Okay.
Sure. Let me, Don Meagher from Casella Waste Systems, and I'm going to have to be speaking about the operating services agreement that we have with the state from memory. So, got to kind of take that into account here. And when you refer to the 6 years, we're actually talking about two different things here. The 6 years is a statutory requirement that applies to the State Planning Office. I think, talk about that, but I'll probably ask Bob to keep me on track if I don't state it exactly correctly. In terms of our operating services agreement with the state, first of all, I think we have to understand that the expansion of the landfill was anticipated and explicitly stated in the state's RFP to select an operator, in our proposal to the state, and then in our contract with the state. It was presumed from the beginning that there would be an expansion and that would be necessary to get 30 years of capacity, which is the term of the agreement. And that 30-year capacity would happen in two pieces: the amendment, which was to go up on the existing footprint, and then go out with an expansion in a second application. It was also anticipated so that everybody had certainty and assurance that that capacity was going to be there, that all was going to happen sooner than later. Understanding, though, that preparing an expansion application, doing all of the field work, takes some time. It takes some time to do that. So in the initial contract, it was anticipated how much time that was going to take, and a deadline was imposed to prepare that expansion application. That deadline got extended because of the time that got occupied on the appeals of the original going up license. We weren't going to start working on the expansion application while those appeals were in play. And those took, I think, in excess of a year to go through the end of all of them. So there was a delay in getting that process started, so the deadline was extended. The deadline was there to make sure that we made progress on that obligation. That was an obligation on us. However, there's another more general obligation in the agreement that says we shall use all diligent efforts to secure an expansion. That's our obligation at our expense. So I don't know if that helps on the agreement, and please ask further questions if I haven't been clear. The 6 years is an obligation by the State Planning Office when they determine that there is 6 years of disposal capacity. I believe it's statewide, not just at the state-owned landfill, but statewide. They need to report to the legislature, and the legislature has to make a decision regarding Carpenter Ridge. Because Carpenter Ridge now is a license the state holds in reserve to be acted upon if the State Planning Office and the legislature deem that there's going to be a shortfall in solid waste disposal capacity in the near future, being 6 years. 6 years being the estimate of the amount of time it would take to do the final engineering, build an access road, build your first cells. Even though that facility has a permit, there's a long lead time to get to the point where you can actually put waste on the ground. And I think the last thing any policymaker, either in the DEP or in the legislature or in the governor's office, wants to face is running out of landfill capacity. When that happens, you got a serious crisis on your hands. In terms of Juniper Ridge, it's a pretty simple math calculation. We have a certain amount of capacity remaining. It's being used up at a certain rate. It's going to take a certain amount of time to get the permits in hand, select a contractor, build the first cell, and we're getting very close to those two paths intersecting. And so the time is to move forward.
Yeah.
Thank you.
But certainly understanding. I think the other thing too that Don has clarified for us is that Casella is the operator. The State Planning Office is a separate entity, even though they own the landfill, and the requirements of the 6 years are on the State Planning Office. They're just using prudence and due diligence as any business would in securing future supplies or future space so that they can meet their obligations under the operating services agreement. Did I summarize that about right?
You did very well.
Okay.
Better than I could.
Well, I didn't actually, until you came up, I was a little muddy on it, but thank you, that helped a lot.
Sure, thank you.
So Don, the deadline you said that was imposed and extended, that was imposed and extended by whom? The State Planning Office?
It was extended by the State Planning Office and us, both understanding that we kind of lost 2 years at the beginning of the contract period. But as Paul Schroeder stated, we did meet the date deadline of having an expansion application in hand by January of 2009. And again, the reason it wasn't submitted is that there was legislation in that session that ultimately came to be enacted that said you had to go through the public benefit determination first before the department could entertain the expansion application. So,
which is why you withdrew that application at that time.
well, we issued public notices in the fall of 2008, anticipating we were going to file the expansion application, but we never filed the application.
No, I remember you stating publicly that you were going to withdraw or not do it, basically.
It could have been that we simply weren't going to submit it, but even though we had a public notice of an intent to file, the application itself did not get submitted because of the legislation that was underway and being discussed, and wanted to let that run its course. And so here we are today, still having not submitted an expansion application, and it's going to be at least 3 years beyond when we thought that was going to happen.
Any other questions? Thank you very much, Don.
Thank you. Glad to come back.
I do have just one other question, Don. This is, you eat, sleep, and breathe this stuff every day, and
unfortunately,
it must be hard. It's hard for me to just keep track of it all. Does Casella, given that worst case scenario, does Casella have any liability to the state under your operating services agreement if, for whatever reason, you run out of landfill space before new ones are permitted and built and all of that?
We do have contractual obligations that we will honor, which would mean reserving capacity for. And if we start to get to the point where we don't have permits and we may exhaust all of the capacity before we have new capacity built, we're going to have to start telling people, find somewhere else.
But
in order
Casella
to
will not have liability for that failure. The state will, right?
No, we will.
By the state also.
Okay, I need to have that, I don't think I fully understand that.
It is our obligation under the operating services agreement to secure all necessary permits.
Well, if you've made all good faith efforts to do that, as you are and have been, then I'm sure that liability would be relieved for Casella, not for the state.
I guess we'd have to refer to lawyers probably.
I know. Well, yeah. My hair hurts already.
But in more, for instance, and you'll see this in the public benefit determinant application, we've given some projections of when the current capacity will be exhausted. And again, that's based on a set of assumptions that are subject to change in both directions, because there is uncertainty for a lot of reasons, which we do get into.
I read it. I read it word for word.
And so some people that have contracts with us for disposal look at that and say, but that's before our contract is out. And what we have said is we are reserving capacity for you till the end of your contract. And if we have to displace other people to accomplish that, that's what will happen. But that's going to be a hardship and an inconvenience and a cost to those customers that are told you have to find somewhere else.
But with those contracts, though, I'm sure there's a force majeure clause that relieves that liability in the event of things that are happening beyond your control.
Yeah, again, I'm not a lawyer, but I would expect failure to obtain a contract is not a force majeure.
Well, a little unusual situation. Usually it's the owner and the operator that's applying. In this case, the operator is applying for the owner.
Right.
And,
On behalf.
So, a little different situation.
There is a distinction, though. That's what I'm trying to get my head around.
Well, that would be between the state and Casellas. And they violated whatever his operating agreement was and stuff like that. That's where that matter would be brought.
Well, let's hope it does not come to that.